Yes, we're ready.
Awesome. Good morning, everybody. Happy Friday Eve. It's Thursday, March the 20th, 2025. This is the Oil Conservation Commission meeting. I'm Gerasimos Rosados. I go by Jerry. I'm the acting director for the Oil Conservation Division. I'm also the acting chair for the Oil Conservation Commission. We'll start our meeting now. We'll do a roll call. As I mentioned, I am Gerasimos Rosados, and I'm the acting chair, and I'll move it over to my right.
Morning, I'm Greg Bloom. I'm the designee of the Commissioner of Public Lands.
Good morning. I'm Dr. William Ampuma, professor at New Mexico Tech, designee of the Energy Secretary.
Thank you, gentlemen. So we got our roll call out of the way. Now we need to approve our March 20th agenda. If I could get a motion for the approval of the agenda.
I so move.
I second.
Excellent. So our agenda is approved. Our agenda stated that our third topic is the approval of the February 20th through the 28th, 2025, and the March 11th, 2025 meeting notes. We do need to augment that a little bit. The March 11th meeting notes are not complete yet, so we will move those to our next meeting. So right now, if I could get a motion to approve the February 20th through 28th, 2025 meeting notes, please.
Mr. Chair, I believe those first minutes are the Empire Goodnight case.
Correct.
So I will sit out the vote on that as I am not a commissioner there.
Okay, thank you.
I move.
And I will second it.
Okay.
So our meeting notes for February 20th through the 28th of 2025 are approved. Okay, we'll move on to our pending cases. Our first case is case number 25237. It's a de novo appeal of an order of the division case 24517. Are all parties present? This is a status conference. Let's start with the OCD.
Good morning, Mr. Chair, Commissioners. This is Jesse Tremaine for the Oil Conservation Division.
Thank you, Mr. Tremaine.
Good morning, Mr. Commissioner. This is Ben Holliday on behalf of Silverback Operating 2.
Mr. Holliday, thank you. Anybody else?
Good morning, Mr. Examiner. This is Jonathan Samaniego, representing American Energy, representative of American Energy.
Excellent. Thank you, Mr. Samaniego. Appreciate it. So we've got all three parties here. Mr. Samaniego, you are appealing the division order, so I'll have you start for us this morning on our status. Just this, as I mentioned, this is a status conference, so we're not hearing it de novo right now.
Okay. Silverback's claim of ownership in the Champion lease, American denies that. Silverback's claim that American interests were quiet titles, American denies that. Silverback's claim through the quiet title that interests in the Champion lease were quiet titled, American denies that. Silverback's presented list of their notifications, and in the list of the quiet title, American finds that very that needs to be cautiously looked at by the commission and the division. I mean, American denies the notifications that they submitted out. It's very precarious that the claimants to the quiet title Silverback is claiming through they didn't notify nobody there, which it's just, I mean, that really needs to be cautiously looked through. American denies all Silverback's claims. American should have or is required to notice because American is an operator and an interest holder in the Champion lease. And because notification was not proper, therefore the applications of Silverback must be dismissed under state law and statutes.
Okay. So, Mr. Samaniego, are you ready to be able to schedule a setting on your side?
Yes.
Okay. Thank you. I'll move over to Mr. Holliday. Mr. Holliday.
Where to begin here? So Silverback in case number, gosh, I have to go back and find the case number, 24517 Silverback is the operator under a two-section unit that was established by order number R23045. All but 2.25 net mineral acres in that entire two-section area are subject to a JOA. So it was a very, very small cleanup pooling. We disagree with Mr. Samoniego's characterization of the title. We also disagree that this is the proper forum to try anything, and then the NMOCD and the OCC doesn't have jurisdiction. This is not the proper place to litigate a title dispute, if he has one. And we're happy to set this for a hearing as soon as pleases the commission.
Excellent. Thank you, Mr. Holliday. Mr. Tremaine.
Good morning, Mr. Chair. There's two things I want to address here. First is the OCD's entry of appearance and notice of intervention.
Mr. Tremaine, I'm going to interrupt you. Can you bring the microphone a little closer? Sorry. Thank you.
I expect OCD's involvement in this case to be likely minimal. The chief question here is a title question, as Mr. Holliday indicated, and the dispute between the parties as to whether Mr. Samaniego and American Energy Resources was entitled to notice regarding compulsory pooling claim. I will venture that my suspicion is that the commission will and should rule based on pleadings associated with those claims. The reason that OCD entered appearance here based on the record is that the leasehold interest purported by Mr. Samaniego includes and is arguably held by a particular well, the Rio Penasco. That well is out of compliance and subject to a stipulated final order with another party who is a registered operator at the time of OCD's enforcement action. We're taking additional investigative steps and enforcement actions related to that and other wells. But to the extent that this commission considers any rights or permissions associated with that well, OCD needs to reserve its ability to participate. To the extent that the commission is going to consider the title claims, the quiet title arguments, et cetera, between Mr. Samaniego and Silverback, we will abstain from that argument, and we're available to schedule either motions or hearing on this at the pleasure of the commission. The second issue is that Mr. Samoniego's filed a motion to strike my appearance as division counsel. I sent a rather strongly worded response to commission clerk regarding that. I don't think we're going to get into the merits of that today, but I urge the commission to deny that motion. It is true that Mr. Samoniego's filed numerous complaints to essentially any email, OCD email that he can identify regarding me doing my job. He's exceedingly unhappy with the enforcement practices regarding inactive wells. There are frivolous and unsupported claims. No actions have been taken. I haven't heard back from the U.S. Department of Justice, for instance, about any concerns with my actions. And it's important that the division has the opportunity to address its interest in enforcing its rules regarding that well. Again, I don't think we're going to get to that issue in the case. Thank you.
Thank you, Mr. Tremaine. As far as the motions to strike Mr. Holliday and to strike Mr. Tremaine, both motions have come up. Commissioners, I motion that we do strike it. I think that both Mr. Holliday and Mr. Tremaine have the ability to be able to discuss on part of both entities. And if you agree, I would need someone to second that.
I concur and I second.
I also agree to that.
Okay, so I think unanimously we're going to agree to strike
To deny.
to deny the motion to strike the two. So we'll let the record reflect that for now. As far as being ready to take this, to bring it in front of the commission, as you all know, the commission's schedule is pretty busy. we are pretty packed. So as far as availabilities, I believe April is out because April has just a massive case going on. 2 full weeks in the month of April for that. Sheila, what does May look like right now?
The May meeting is May 15th, and there's room on that docket.
I'm sorry, can you repeat that?
Sure, the meeting is set for May 15th, and there is room on that docket for a case.
Did you say there is or there is?
There is. We
There
could
is.
schedule it. on
Okay,
May
I
15th.
apologize. I'm in a weird echo in the room and I didn't hear it. So my apologies. Okay, so the soonest we probably could get to this case is June. I know that that's almost 3 months out, but as I said, the commission's pretty packed and the calendars are getting pretty full. Does that work for all 3 parties? Go
Yes,
ahead,
Mr.
Mr.
Chair.
Tremaine. I'm sorry, Mr. Tremaine.
Yes, for the division.
Okay, Mr. Samaniego.
Yes.
Okay, Mr. Holliday.
Yes, sir.
Okay, excellent. So we can set this for the June hearing for that instance. Anything else anybody would like to bring up regarding the status conference? The status conference for this particular case.
I would like to make on the record that Jesse Tremaine's statements regarding American, it was out of line. It was patently incorrect.
Okay.
For the fact that the topics that he brought up were irrelevant to the matter at hand. The matters he brought forth, those are matters to be brought forth for a matter for violation hearing. This is a matter regarding notice of polling. For the fact that Tremaine brings up violations whenever we're simply talking about proper notification, is in plain sight of his maliciousness. I reported that I reported him to the Department of Justice, the New Mexico Department of Justice, and today here he is maliciously coming into a hearing with irrelevant topics with the sole purpose of hurting America.
Mr. Samaniego, Mr. Samaniego, I'm going to interrupt you. 1 second. We're not here to discuss the merits of Mr. Tremaine, and I would appreciate it if we use some decorum and we used respect when we're talking about individuals. Just like Mr. Tremaine calls you Mr. Samaniego, I would appreciate it if you also use the same with Mr. Tremaine. Don't just say Tremaine. And second of all, we will be hearing this case. So why don't we, I understand your frustration and I note it. The commission definitely understands that there is frustration here. We are happy to discuss the merits of that in June. But let's keep some respect and some decorum, please.
If I may just add one more thing, there was 2 other qualified attorneys, Christopher Moander and Christy Trevor, and those are 2 qualified attorneys that can hear this matter. The fact that Jesse Tremaine feels it's under his sole obligation to hear American and be involved in American's hearing is erroneous, and for the commission to allow that to proceed with him being involved is negligent.
Mr. Samaniego, I appreciate it. And we definitely, as I stated, noted that you have your concerns, and that is on the record as well. In June, we will definitely hash all that out, okay?
And can I just get the hearing date one more time? I can write it down.
Yeah, it'll be June 2025. And what's the exact date, Sheila, for June?
It'll be June 15th.
June 15th, 2025.
Yes, sir.
Or May 15th.
Nope, not May.
It's Sunday.
June 15th is Sunday, Sheila.
Oh, is that a Sunday? Right now it's scheduled for June 19th, but that is a federal holiday. So I'm going to have to move the hearing and I'm going to move it to the Monday of that week. And I thought it was the 15th, but if it's the 16th,
So the 16th, June 16th, Mr. Samaniego.
Mr. Chair,
Yes,
I'm not available.
you're not available on the 16th.
Already booked.
It'll be that week of June 16th at some point, Mr. Samaniego. We'll have a date solidified and we'll get it to you, okay?
Yes, sir.
Thank you. Anything else? Excellent. Thank you, everybody. We'll move on to our next case. Our next case is case number 24683. It's the application for rulemaking to amend 19.15.2, 19.15.5, 19.15.8, 19.15.9, and 19.15.25 of the New Mexico Administrative Code. This is a status conference. Are all parties present? We'll start with you.
Thank you, Mr. Chair. Tanis Fox, representing applicants in this matter, and I'm here today with Morgan O'Grady from our office, and online are Kyle Tisdale and Matt Nikiel.
Excellent. Thank you, Ms. Fox.
Good morning, Mr. Chair, members of the commission. Michael Felderwert with the Santa Fe Office of Holland and Hart on behalf of OCC USA.
Thank you, Mr. Felderwert.
Jesse Tremaine on behalf of the Oil Conservation Division.
Thank you, Mr. Tremaine. Okay, Ms. Fox, we'll start with you.
Good morning, Mr. Chair. Can you hear me?
I apologize. Yes, Mr. Suazo, my apologies.
All right. Good morning, Mr. Chair and Commissioners. Miguel Suazo with Beatty and Wozniak appearing on behalf of the New Mexico Oil and Gas Association this morning.
Excellent. Thank you. I see Mr. Tisdale. Is there anybody else on the platform?
Yes, Commissioner, this is Ann Tripp for Hinkle Shaner on behalf of the Independent Petroleum Association of New Mexico.
Thank you, Ms. Tripp. Anybody else?
Yeah, Mr. Chairman, this is Matthias Sayer on behalf of EOG.
Mr. Sayer, thank you. Anybody else? My apologies. As I always say on these meetings, I haven't had enough coffee by 9 a.m., so I slip up sometimes. Ms. Fox, we'll now start with you.
Thank you. Thank you, Mr. Chair. You might recall at the last status conference last month, all the parties concurred that the April hearing that had been set by this commission should be vacated. And the reason for that was that the parties met in October to discuss applicants' proposals. At that point in time, OCD stated that it would have a red line, that would have alternate proposals for the parties. So we were all very interested to know what those were. Those proposals were anticipated to be submitted to the parties before the end of the year, but because of workload issues, they were not, and they were submitted, as you might recall, in the middle of February. And so the industry at that point in time asked for 30 days to try to figure out a new hearing date. Last week, OCD circulated a proposed hearing schedule for the parties, and the proposed hearing schedule had dates for applicants filing an amended petition, for the filing of direct testimony and exhibits, for the filing of rebuttal testimony in the exhibits, and then a hearing date of about approximately 2 weeks, maybe 2+ weeks, starting October 14th, with flexibility within those dates. We wrote back to OCD. We concur with its proposed schedule. We haven't heard from industry parties, although I did have a conversation with Mr. Felderwert and Mr. Rankin this morning. We're amenable to, in terms of the dates that OCD has proposed, we're amenable to flexibility within the dates for filing the amended petition, the direct testimony, the rebuttal. The one, I guess, request we have is that for the hearing, that it not extend beyond the first or second week of November, that it not bleed over into the holiday season, because we've got a lot of counsel, a lot of experts, many of whom are going to be flying in from out of state. We have commission members. We have the hearing officer. It's a lot. These hearings, as you know, are a lot of work, and we would like to have this hearing ended before the holiday season gets started and without having the hearing hanging over us. That's our one request.
Okay.
Other than that, we have flexibility between now and and a hearing.
Okay, excellent. Mr. Feldewert, we'll go to you next.
Ms. Fox did a good job of summarizing, I think, where we are. The only thing is I don't see a date on here for filing any kind of an amended petition. But I suppose that's something that we can discuss and agree upon in formulating a scheduling order. But we don't have a problem with the proposed October hearing date. I do note that the filing of full testimony and exhibits is June 13th, which if we hold in October would be 4 months before the hearing. Seems like an awfully long time, but
4 months go fast.
I guess they do go fast, yeah. And then there's provision in here for filing rebuttal testimony. In my experience, the only thing I'd want to reserve is the ability to actually challenge whether it's rebuttal testimony or whether it's something that should have been filed initially.
Okay. Mr. Tremaine.
Thank you, Mr. Chair and Commission. I think we've summarized the situation well. Waiting on feedback on specific dates from the parties. I know Mr. Suazo is traveling, and so I'm hopeful that we can get a joint stipulated order in. I did not put in or propose yet a amended petition deadline. I think that's something we can and should talk about with the parties. But we're discussing the scheduling of additional stakeholder meetings in April. So I was leaving that open-ended for now to allow what we hope and expect will be feedback from NMOGA and other industry partners. But that's something that we can fill in the next couple of weeks. I do think that we want to take the time to hammer out any areas of necessary flexibility with the filing dates, but that the most important thing is the hearing date, that we get that scheduled. We share the concern that going into the holidays, this is going to be difficult for all parties in the commission. And I proposed 2+ weeks at this point, because I think if it's structured that way, we can always pull that back rather than extending it out, as we've seen with some other cases that have gone on beyond the currently scheduled period. So if we could schedule 2 to 3 weeks, and then hopefully we can whittle it down from there.
Okay. Thank you, Mr. Tremaine. Mr. Suazo.
Sure. I think Mr. Feldewert and Ms. Fox did a good job summarizing where we are. I did confer with NMOGA, and I think, there's no issues with the October date per se. I think the better question, and maybe the place we should start, is to learn whether or not the commission is available on those dates. And if not, hopefully we can push it back a bit, but in such a way that it won't interfere with the holidays. With respect to the earlier dates, I think NMOGA is still kind of waiting to see what results from the legislative session. Is, you all can imagine, they've been pretty focused on that. There are some pieces of legislation that could impact this rulemaking. We'll know the outcome of that, I think, fairly soon, but we don't know it yet. And so once we have some clarity with respect to how the session ends and what impacts it might have on this rulemaking, I think that NMOGA will be prepared to sit down with the parties and agree upon some firm dates. I just don't think that we can do that today, but I do expect we'll be able to do that in the next few weeks.
Excellent. Thank you. Ms. Tripp.
Yes, thank you, Commissioner. IPNM is in much a similar situation as NMOGA. We don't have a problem with the October 14 2+ week hearing dates, as long as it does accord with the commission's schedule, and we could push a week or two beyond as well. And so I don't have anything additional to add. I think we'll be available and in a better position after the legislature close. And I am aware that there's several parties that may have amendments or revisions. And so I think those interim deadlines, which are discussed right now, are open for conferral between the parties.
Excellent. Thank you. Mr. Sayer.
Thank you, Mr. Chairman. Nothing to add. We generally are supportive of the division's proposed schedule.
Okay. Excellent. And Ms. Fox, you were speaking in behalf of the other two gentlemen on the platform, correct? Okay. I believe that this is all fine and dandy with the commission as well. The only caveat to it is the commission chair is going to be out of the country the first 2.5 weeks of October. So it would have to be the week of the 20th instead of the week of the 13th. So it would just be moved by 1 week, if at all possible. As I mentioned, I'll be out of the country. So I'd just move it by 1 week. It'd still be for the holidays. But it would just probably be the week of the 20th of October. If that's okay with all the parties, we could tentatively schedule it for that.
That's fine with applicants.
Okay.
Fine with Oxy.
Agreed.
I'm going to just go Mr. Suazo.
That's fine with Namoga, Mr. Chair.
Okay, Ms. Tripp.
That's fine with IPNM.
Okay, Mr. Sayer.
Looks good.
Okay. So we can set it for the week of starting Monday, the 20th of October. Commissioners, does that work for you all?
Let me check the third week there.
Okay.
Works for me, Mr. Chair.
Okay.
How long will this go for?
They just said 2 weeks, possibly a little more.
So I'll ask that when it gets in closer, because I do teach,
Right.
and I cannot miss classes for 2 straight weeks. So, but I teach only one class. So we can work it out in such a way that I can be relieved to go teach at some point.
I think all parties could take that into account for a day during the week, so the commissioner can teach his class. We can work that schedule out and work with that. But it does the 20th of October starting this work for you, Commissioner?
Yes.
Okay. Then let's plan on that. We'll set it on the books for the week of the 20th of October. We just need another status hearing here. When would you all like another status hearing?
Mr. Chair, I think next month would be good because we should be able to have decided among ourselves sort of these interim dates between now and the hearing October 20th.
So the commission meeting date was canceled for next month because we've got the 2 weeks for the Goodnight Empire case, where I'm happy to hear it at the beginning of that, but that's April 7th. That gives you less than 2 weeks to meet.
Whatever the pleasure of the commission.
I mean,
Shoot for May.
To
Should we just do May?
just Ms. Fox, I'm just going to interrupt. Being that legislative session is ending this weekend, you all may need a little extra time just to regroup with what comes out of the legislature. So maybe the May hearing would be best for everyone because, as I said, the April one starts right off April 7th. So, but I leave that up to you. That's just my suggestion.
That's fine. May's fine.
The May.
I hope that we can get agreement among the parties in the next, say, 2 weeks, because the session will end Saturday at noon.
Right.
Mr. Chair, I would echo that. I think it would benefit all parties to have this sorted out, the schedule sorted out in the next couple of weeks. I know that session creates a lot of open-ended questions, but tracking what's happening there with the various bills that would potentially impact this particular rulemaking, I think we're looking at kind of a Hail Mary for any of that to pass at this point. So the particular bills are still in committee. So the likelihood that the statutory foundation upon which this petition is based substantially changes in the next week is exceedingly low. And I think we don't want to push decisions on these filing deadlines out all the way to May because that's going to give all of the parties, as currently proposed, only 30 days to turn around for direct testimony. So we're all preparing for this based on the current red lines with that expectation that there's going to be a direct testimony filing deadline sometime in the middle of the summer. And it doesn't benefit any party to wait to make that decision until the middle of May. So I would say I will encourage the parties to work with us and we'll try to get something filed with the commission in advance of the next status conference, and the commission can schedule the next status at whenever it chooses. But I think we need to get something submitted as soon as possible.
Okay, Mr. Feldort, you still sticking with May?
It's not a strong opinion, no.
Okay, you could go either way.
I'd go either way.
Okay, I'll go on to the platform, Mr. Suazo.
Yeah, Mr. Chair, I tend to agree with, Mr. Tremaine's position. That being said, the chances of this legislation passing, I think at this point are low, but they're also not zero. And so I would like to, be in the position to work with the parties and agree to a procedural schedule before May. I'm hopeful that we can do that. We'll definitely endeavor to do that. But, until we kind of have some clarity, we can't do that just yet. But I agree, given the dates that the parties have proposed, that Namoga still needs to assess. We just need a little bit more time, but if we stick to those dates, it's going to be kind of tight in terms of time. If we wait all the way till May to agree to a schedule. So I propose that we put a status conference for May on the schedule, but also, commit to the parties that we'll do our utmost to work with them to try and pin down the actual dates before the May status conference.
Okay, Ms. Tripp?
Yes, Commissioner, I agree that having that May status conference as a backstop, but that IPNM is agreeable to working with everyone well ahead of that.
Okay, thank you. Mr. Sayer?
Yeah, we agree with Mr. Tremaine.
Okay, so let's do it this way. We'll put a status conference for April the 7th. We'll begin the day with the status conference, April 7th. And if we need more time, we need more time. We can regroup at that point. How does that sound for everybody?
Mr.
Ms.
Chair,
Fox, yeah.
perfect.
Excellent. Mr. Feldert, you're okay with that?
That's fine. Thank you.
Okay, Mr. Tremaine?
Excellent. Thank you.
Excellent. Mr. Suazo?
That's fine with Namoga.
Ms. Tripp? Thank you, Mr. Suazo.
Yes, that's fine. Thank you.
Excellent. Thank you, Mr. Sayer.
Thank you, Mr. Chairman.
Okay, we'll see you all in 2 weeks. Appreciate it. Thank you.
Thank you.
Thank you.
Moving on to our next case. And actually, you know what we'll do? Let's take a 10-minute break just so everybody can regroup, get chairs, etc. And we'll meet back here at 9:42. Thank you. Okay. We're back from break. We'll go on to our next case for today. This is an evidentiary hearing before the Oil Conservation Commission. This is case number 24881. It's the application of Northwind Midstream Partners LLC for approval of an additional redundant acid gas injection well and to amend order number R20913 as amended and SWD 2622 to authorize an increased shared maximum daily injection rate in Lee County, New Mexico. Are all parties present? I'll
Chair.
start from my right and we'll move across. Mr. Rankin.
Chair Rosados, Commissioners, may it please the Commission, Adam Rankin appearing this morning on behalf of the applicant in this case with Santa Fe Office of Holland and Hart.
Thank you, Mr. Rankin.
Chairman and Commissioners, on behalf of Desert Ram South Ranch Inc. and intervener, I am Reagan Marble along with my co-counsel and colleague, Ms. Caitlin Luck.
Thank you, Mr. Marble. Appreciate it.
Thank you, Chair and Commissioners. Jesse Tremaine for the Oil Conservation Division.
Excellent. Thank you. Okay. Are we ready to proceed? We'll start with you, Mr. Rankin. Okay. Yeah, I'm sorry. We'll do preliminary matters and any motions. So, Mr. Marble, I believe you had a motion.
We do have a motion to stay, Mr. Chairman, if you'd like us to take that up at this time.
Yes, let's take it up, please.
Good morning. Again, for the record, my name is Reagan Marble, and along with my colleague, Ms. Caitlin Luck, I represent Desert Ram South Ranch, Inc., an adjoining surface owner to the Titan facility that's at issue in this application today. This motion to stay, in this case, from our perspective, is about whether a company can succeed on its application for a permit to inject acid gas beneath land that it does not own an interest in. We ask the Commission to stay the application presented today for a myriad of reasons, but three of which I'll discuss with you this morning. The first is that Northwind does not have a good faith basis, as required by this Commission, to drill and operate the AGI well. The second is that Northwind's reliance in their response to our motion to stay on the Snyder Ranch's case is misplaced. The third is that this issue is not an issue new to this Commission. And then I'll finally address standing, which we should dispose of rather quickly. Turning to my first point, Northwind does not have a good faith basis to drill and operate the Titan 4 AGI well. I believe case number 13492 by this Commission in the early 2000s states the principles that should form the basis of our analysis and why this Commission should stay the application. 13492 involved Chesapeake. Chesapeake had applied for a permit to drill an oil and gas well on the southwest quarter of Section 4. It had actually obtained the permit. After the permit was issued, Kaiser Francis, Sampson, and Mewburn came back to the Commission and filed a motion to cancel the permit on the basis that Chesapeake did not own any interest in the southwest quarter of Section 4. The Commission ended up canceling Chesapeake's permit, and they laid forth the analysis in that order, and I believe the analysis that this Commission should follow in the motion to stay today. The first question the Commission presented in its order that should be part of the analysis that they said the Commission should approach is, does the applicant have a good faith claim to both drill and operate the well they are applying for? Then this Commission stated it another way. They said, do they have a good faith claim to title for the property? They then went on to discuss that title is simply a person transferring its interest or a interest in real property to another. Then Chesapeake responded to both Kaiser Francis and Sampson about this Commission's jurisdiction on title disputes. And Commissioners and Chairman, I understand. I don't want to create any more work for you. I don't want to create any more work for Mr. Tremaine. We should not have title disputes in this tribunal. In Texas, my home state, our neighbor to the east, we approach the title matters very similarly. So does the state of Oklahoma. But there is some preliminary piece that an applicant must show in order to obtain a permit. And that's because both New Mexico, Texas, and Oklahoma have premised their jurisdiction that has been established in this Commission on the premise that an applicant has some scope within property rights to do the thing they are asking the Commission to give them. So in this instance, The Chesapeake applicant said the commission has no jurisdiction to hear title matters. Even if we don't own an interest in this piece of property, the commission can't cancel the application on that basis. In its order, this commission said they're right. And does not have jurisdiction to determine title or the right to occupy. However, prudence dictates that the commission ought not to issue a permit where the party applicant clearly does not have the right to conduct the activity contemplated. You will see, without a doubt today, from their application and from the testimony that will be presented, that Northwind does not have the right to conduct the contemplated activity. The activity contemplated by their application is the injection of acid gas, being primarily carbon dioxide with 20% of the stream being H2S. That acid gas, under any case model presented by Northwind, occupies my client, Desert Ram South Ranch Inc.'s subsurface. It also occupies the state of New Mexico's subsurface under every model. Turning to my next point, commissioners and Mr. Chairman, this is not a new concept for this commission. Last year, and actually the predecessor to Northwind, Salt Creek, had filed an application for another AGI well. The state of New Mexico, the largest landowner in the state, intervened on the basis that the plume would migrate under state-owned lands, and there was no real property instrument or deal in place between Salt Creek and the state of New Mexico to compensate the state of New Mexico for that subsurface pore space. They intervened on the same basis that Desert Ram North Ranch Inc. intervenes on today. There was an agreement struck between the applicant and the state of New Mexico at that time. That is one of the reasons we are asking for the stay, to give Northwind and Desert Ram a chance to negotiate an agreement for occupation of pore space. But that has not happened to date. Turning to my next point, Northwind's reliance on the Snyder Ranch case is misplaced. If you read the response to our motion to stay, it is primarily on two bases. One, that there is no standing, and I'll address that here in just a moment. The primary point, though, is that they wrap themselves in the cloak of the Snyder Ranch's case. If the commissioners and the chairman recall the Snyder Ranch case, in Snyder Ranch, the issue was a saltwater disposal injection well. And the primary question before this commission was whether that salt water was going to migrate underneath the ranch known as Snyder Ranch. And there was some discussion in that case about a fault line that ran between the property owned by the applicant and the property owned by Snyder Ranch, and whether it would actually migrate across. The commission, in their findings of fact, noted that they did not believe the salt water would migrate across underneath Snyder Ranches. That's important and dispositive for the position that Mr. Rankin and Northwind take today. That is not the issue before this commission today. There is a clear admittance by Northwind in their application under any plume model that they have submitted that the acid gas injected through the proposed well will cross over onto my client's property and will occupy its pore space. That's important for a couple of reasons, because that takes the application from the question of will this substance occupy the pore space of another to we are telling the commission the substance will occupy the pore space of another. And if this commission's jurisdiction is premised on a good faith right to conduct the activity that they are asking to do in the application, and they admit that they don't have any property rights to do so, then the Snyder Ranch case doesn't apply, because that was a case without the substance crossing over the property line. The last issue that I'll address as part of this motion to stay is the second part of Northwind's response to our motion to stay, which was standing. Northwind argues that Desert Ram does not have standing to intervene in this matter for two reasons. Because one, it isn't the surface owner of the actual tract where the well is drilled. And then two, that they don't fall under the definition of an affected person. And they talk about the definition of the affected person being an operator, a working interest owner, or a mineral owner. We disagree wholeheartedly, and Northwind has presented an argument that is inapposite of the rules. The rules in the state of New Mexico, specifically 1915-410A2, state that a party to an adjudicatory proceeding, and in layman's terms, that is a party with standing, shall include a person to whom a statute, rule, or order requires notice. 1915-412A7 is the rule that required notice to Northwind, and that is to notify a surface owner within 1/2 mile of the site. You can see simply from the application that the surface hole location, if that qualifies as the site, or the bottom hole location, if that qualifies as the site, or the total tract that's being injected into, if that qualifies as a site, that Desert Ram South Ranch Inc. is a surface owner within a mile. In fact, they surround the entire site that Northwind has applied with. And we have a witness today that will discuss some of those issues. So because Desert Ram is a surface owner within a 1/2 mile of the site, they undoubtedly have standing to intervene in this proceeding. To quickly recap, Mr. Commissioners and Mr. Chairman, we ask that this commission stay the application of Northwind because Northwind does not have a good faith basis to conduct the activity which they are seeking because they have no right to the pore space, that their reliance on Snyder Ranches is misplaced, that this is not a new issue for this commission, and in fact, it is an ever increasing and more important one in the legislature pending right now is a pore space bill. And finally, that we have standing under 1915-412A7. I'm happy to answer any questions that the commission may have. Thank you.
Thank you, Mr. Marble. Commissioners, did you have any questions?
Mr. Chair, I want to hear from the other parties, with regards to whether there could be a trespass or not. Yeah.
I would like to hear that as well, but anything specific for Mr. Marble?
No, Mr. Chair.
No, at this
Okay.
time.
Excellent. Thank you, Mr. Marble. Appreciate it. Mr. Rankin, we'll turn to you.
Thank you. Good morning, Chair Rosados, commissioners. May it please the commission. Desert Ram, in this case, moves the commission to cede its legislatively delegated authority to determine whether or not Northwind's application meets the technical qualifications for approval pending the outcome of what is purely a contractual dispute over private property interests in district court. The commission should reject Desert Ram's invitation to abdicate its authority, as the commission has repeatedly done in prior similar circumstances. Desert Ram is already seeking to redress its alleged injuries through a lawsuit filed in district court. That is the forum where its claims about potential future subsurface pore space trespass should be adjudicated, not here. The commission has long made clear that where parties have a dispute over property rights or private interests, it's a matter for district court. This includes instances where there may even be some, quote, some evidence that fluids injected pursuant to the license granted by the commission's order might migrate beyond the lateral limits of the particular tract on which the injection facility will be located, end quote. The commission nonetheless has concluded that, quote, it is unnecessary that the commission make a finding with respect to that possibility, end quote. I'm quoting there from Commission Order number R12546 at paragraph 26 that's cited in our papers. Now, citing the Snyder Ranch's Supreme Court case, the commission explained in that order that I just cited to, that if, quote, activity conducted within the scope of the permit exceeds those property rights, this would be a matter for adjudication in the courts and not within the jurisdiction or competence of the commission. In this case, commissioners, we have clear authority to inject on the property where the well is located, where the bottom hole is located. Northwind owns more than 200 acres where the well is located and where the bottom hole is located. And so it has clear authority to inject on the location and in the bottom hole where its well is located. And I will get into the additional arguments shortly. Now, in an earlier case, the commission, again, citing Snyder Ranch, has made clear that it does not determine whether an applicant can validly claim property interests in the property subject to the application, and therefore whether the applicant is duly authorized to manage the operation of the injection or operations on that property. That issue is, quote, the exclusive jurisdiction of the courts. Again, I'm quoting here from another case before the commission. It's order number R11855B. Again, that's cited in our papers. Now here, Desert Ram contends the commission cannot issue injection permits that would exceed the limits of the applicant's property rights. And they cite to Snyder Ranch's, the Supreme Court case in support of their position. But if that were a correct interpretation of the law, the commission would necessarily be required to determine whether the applicant can validly claim the property rights. They'd have to do an assessment and determination of whether or not those property rights are valid. And the commission has repeatedly said it's not in our jurisdiction. It's not within the scope of our authority. It would need to make that determination, and it has repeatedly indicated properly that it is not within its legislative authority to do so. Note, nothing the commission would do here today within its proper authority to determine whether the injection is appropriate or not based on the technical merits of the case would impede with Desert Ram's ability to seek relief or redress any purported injury in district court. And Desert Ram makes abundantly clear that its objections and claims are entirely related solely to a potential future subsurface pore space dispute, which claims belong only in district court. Now, Desert Ram owns no mineral rights. The Devonian formation in this area has already been determined to be non-hydrocarbon bearing. There's no dispute over correlative rights. There's no dispute over waste. Those are the jurisdiction and the authority over which the commission has reigned, not whether that there's a subsurface trespass or there's impairment of pore space rights. The dispute is that Desert Ram raises here is simply over pore space, plain and simple. Desert Ram makes that unabashedly clear through the evidence it seeks to admit and the permit conditions it's improperly requesting the commission to impose. Two of the four exhibits it's identified in its pre-hearing statement are the purchase and sale agreement, a contract between the parties, and the First Amendment to that agreement. They're asking the commission now to make interpretations of a private contractual agreement between the parties. That's not within the commission's expertise. It's not within the commission's jurisdiction. It's something that belongs before the district court, and they have already proceeded down that path. Each permit condition that they've now proposed is designed to use the commission's statutory powers, which is intended to prevent waste and protect correlative rights, to instead monitor their private property interests. That is an improper use and application of the statutory authority of the commission, and it should be rejected. Desert Ram's objections are based on alleged subsurface pore space trespass that might arise sometime in the future. Those claims implicate property rights that are not legally cognizable before the commission, as the commission has long recognized. Not only are Desert Ram's claims not proper for consideration before the commission, but because their objections are entirely based on a property dispute over private interests, they also cannot set out a proper procedural basis for us to stay this hearing. There's simply no reason to stay when the objections they've raised are not legally cognizable before the commission. But in support of their motion to stay, they cite and rely on a procedure and authority that governs stays of orders pending appeal only. That procedure has no application here. And as important, the commission should deny the motion because Desert Ram is not even a proper party to this proceeding, as Mr. Marble has attempted to refute. The commission should deny the stay to avoid undermining the commission's authority to function within its administrative domain. Granting Desert Ram stay would signal to other entities with private contractual property right disputes that they can use the commission to leverage their position in their private disputes that are unrelated to the commission's authority. That's a terrible outcome and should be rejected. The motion should be denied and the hearing should be permitted to proceed. Now, I want to make a couple of points before I relinquish my time. Desert Ram is making the argument that Northwind has no good faith basis to believe that it has the right to inject on the location and in the property that is proposing to inject. As I mentioned, Northwind owns approximately 210 acres of surface estate under two separate warranty deeds that cover all of its surface facilities and the bottom hole locations for all of its existing and proposed AGI wells. We have submitted those as part of the evidence in this case. There were deeds filed of record with the county in Lee County, and we'll be presenting that as part of our case. Now, Desert Ram and its motion for stay cites to a provision in the purchase and sale agreement between the parties, which is subject to a confidentiality agreement. But they cite to this provision in their motion for stay that that actually provides that Northwind has the express agreement and consent from HydroSource to inject treated acid gas through multiple AGI wells, except for limited circumstances that are not applicable here. Okay, that provision expressly grants Northwind the right and consents to Northwind's right to inject into the properties, except for limited circumstances that are not applicable here. Now, HydroSource, to be clear, okay, and to demonstrate the good faith basis to inject, HydroSource and Desert Ram did not object to the most recent Northwind application to amend the AGI number 2, which is a Devonian well as well, with a projected plume extending out about 2 miles into HydroSource's properties. That application was filed back in June of 2024, before HydroSource sold 140 acres of property to Northwind. Knowing, HydroSource got notice of that application, knowing that the plume was going to extend more than 2 miles out into HydroSource's property. HydroSource nonetheless made the sale, did not object to the application, and conveyed its property interests to Northwind. Now that Northwind is filing a second application with an slightly incremental increase in the extent of that plume, HydroSource is objecting, claiming that they had no notion or didn't understand that the plume was going to extend onto their property. They're making a claim here that is a private property interest claim. They're asking the commission to review and interpret private contractual rights and interests between the party that the commission has no authority to do. All we need to do at this point, Mr. Chair and commissioners, is demonstrate that Northwind has a good faith basis to make the injection that it proposes to do. It has done that through the special warranty deeds and through the express provision that HydroSource itself relies on, which indicates clearly that they have the consent and agreement of HydroSource to inject through multiple AGI wells, except for these limited circumstances that are not applicable here. With that, we ask that the commission deny the motion for stay, allow the parties to present their evidence, Northwind to present its evidence, and take the matter under consideration.
Thank you, Mr. Rankin. Appreciate it. Mr. Marble, I saw your finger over the microphone. I'd like to hear from OCD, and then we can circle back.
Mr. Chair and commissioners, thank you. I'd like to provide a couple observations to hopefully help establish the lay of the land here. The division does agree that in various matters, OCD and OCC need to rely upon and verify limited access, limited aspects of ownership, mineral rights, operating rights, et cetera. The way that happens is typically in reliance on certification and representation of the parties. Those are not mineral rights, and ownership are not things that OCD or OCC, in my knowledge, have ever affirmatively adjudicated where there's a dispute. So these cases do involve aspects and representations of ownership. However, where there are property disputes, those properly belong in district court or subsequent appeal. The second issue in this case is the issue of pore space. And I will note that this is not, in my opinion, definitively settled law. There are indications in old New Mexico case law that New Mexico is likely to adopt the American rule, i.e. that pore space belongs to the surface owner. OCD agrees with that interpretation and would advocate for that interpretation as a general matter. But I can't point to a case that says that. This, contrary to my comments in the last case, this is something that hopefully we may see some resolution on in the legislative session. And OCD has provided comments consistent with my statements here today. So issues of pore space, ownership, and severability are central to the dispute between Northwind and Desert Ram. OCD has a position that we advocate for regarding who owns that and whether pore space is severable, but it's not entirely settled. So absent that clarity, that may be an issue that is appropriate for a district court as well. I think there's clear division and commission authority to pool minerals. I don't believe that is disputed. I would argue that under existing authorities, that it also extends to pooling of pore space. Again, we haven't tested that to my knowledge. So I think that when approving injection into pore space, such as saltwater disposal wells, AGI wells, I believe that already exists under OCD authority. Ultimately, where I land is that I have to agree in certain respects with Mr. Rankin that the issue here is a property and valuation dispute. I think that the division and the commission have the authority to essentially pool the space and to authorize the injection of the AGI. That's been the practice in the past for various different forms of injection. I think what's important to the division in this matter is that we get to the technical merits and that the central question is, let's examine this plume modeling. In the various filings between the parties, there are discrepancies between what the plume modeling says and what it doesn't say. I think that technical question is central to how the commission should view aspects of the motions, and we need to get to that through the technical testimony. So with those observations and statements regarding arguably unsettled law, I think that ultimately, to the extent that the motions are related to a dispute between about property and valuations, OCD does not take a position, but we do take the position that the commission has the authority to authorize the AGI, and that regardless of its projected impact on pore space, and we need to examine the modeling relative to previous models submitted for the other AGI wells injecting into the same formation.
Thank you, Mr. Rankin. Mr. Marble.
Thank you, Mr. Chairman and Commissioners. Short rebuttal. First, to answer Dr. Ampoma's question earlier about whether this is a trespass, it is undoubtedly a trespass, is the occupation of space not owned by a person. However, I want to be clear that this commission does not have jurisdiction over trespass. As much as I want you guys to decide issues like that, that is exclusive jurisdiction within the district court. But I think the question is relevant for purposes of determining whether someone has a good faith basis to conduct the activity that they seek from this commission. Turning to a point that Mr. Rankin made, he stated that I and Desert Ram are requesting that this commission interpret a contract. We are not. There is no way, shape, or form we are asking this commission to interpret a contract or a deed. We have filed confidentially the purchase and sale agreement between my client and Northwind in the event that Northwind raised the no interference clause so that we could discuss why the no interference clause does not apply. But we are not asking this commission to interpret the status of an oil and gas lease, right? You hear that all the time in applications for permit to drill, just like Texas and Oklahoma do. That lease terminated. That's not within the jurisdiction of this court. That's not the property rights analysis we're asking this commission to do. In fact, we're not asking this commission to do any property rights analysis. The sole question we are asking this commission to ask Northwind is the same question that this commission asked Chesapeake in the 13492 matter. And that question that the commission asked Chesapeake was, do you have any evidence of a claim to title? And here, Northwind does not. They can't point to a deed. They can't point to a lease. They can't point to a license that gives them the right to conduct the activity that they ask this commission to give them. And that activity Northwind is asking you to look just at a portion, the portion of pore space that they own. But that's not the activity that they seek permission to do here today. They're asking you for permission to inject a plume that over 30 years occupies multiple miles. And whether it's a condition at the end of this proceeding that addresses that issue or a temporary stay so the parties in the OCD can go work this out, I'm not sure what the answer is. But I can tell you that there's no good faith basis for that portion of the activity that they seek permission to do today. A few more brief points on rebuttal. I appreciated Mr. Tremaine's OCD position that pore space may not be a settled issue in the state of New Mexico. I disagree slightly. I believe that it's all but settled. And in fact, I rely on a very important paper written by a very smart lawyer named Mr. Rankin back in 2007 that says that pore space should be an attribute of the surface that he prepared with two other lawyers for the state of New Mexico. I don't think there is any legal position in this room where any of us would disagree that pore space would belong to the surface owner, which is what Desert Ram is today. The point that I do want to raise in response to Mr. Tremaine's rebuttal is he talks about authority that an applicant may have to force pool in the context of a disposal well. He says that that has not been done in this context yet, but that they may have that authority. I want to be very clear that authority has not been exercised in this case. It has not been exercised in this case, despite multiple case models that talk about impacting property that is not owned by Northwind. And a solution may be a temporary stay and a request to file a forced pooling application in the context of an AGI well. But that has not happened today. It is for these reasons, Commissioners and Mr. Chairman, that we ask this commission to stay this application. Thank you.
Thank you, Mr. Marble. Commissioners.
Mr. Chair, there seems to be a matter of law in this argument. So I want to hear from the Commission Counsel if he has any advice.
Agreed.
Mr. Chair, good morning. This revolves around Commission Rule 19-15-423B, stays of commission orders. It has two elements. First, a party, and then the stay is necessary to prevent waste, protect qualitative rights, protect public health or the environment, or prevent gross negative consequences to an affected party. So two elements, a party and then the ramifications. I think what you've heard today and from the papers, there is a dispute on the first element of whether Desert Ram is a party. I think Desert Ram's argument is they are a party because they are a successor in interest or business of Hydrosoil. I think the record reflects that Hydrosoil did receive notice from Northwind. So the first question is, if Hydrosoil is a party, then does that extend to Desert Ram? There's dispute about that. And then the second element is it necessary to prevent waste, ... And that goes to your question, Professor. Again, there seems to be dispute from the papers and from the argument that Desert Ram says it's undisputed, where Northwind says the issue of the plume is not, well, he had some precise language, but he disputed that it was going to go across property. So it's possible that you may want to hear more technical testimony. It may be at this point you feel like there is enough information to prove that second element, that there are gross negative consequences to affected party. Or you may say, I'm not ready to reach that conclusion. I'd like to hear from the experts, since there seems to be some technical dispute about the plume's potential. So to reiterate, two elements, a party and then the negative consequences. And you may reach those conclusions now, or you may say there's just not enough evidence right now for me to make those determinations. I'll deny the motion. Let's hear the technical evidence, see where the facts take us. And then you may deny the permit, grant the permit with conditions. At that point, you may say, we're going to not make a decision today and let the parties enter into negotiations. There's a universe of different options, but I'm speaking too much. Again, the rule has two elements, a party and whether there's been proof of negative consequence.
Council, I thought Mr. Rankin did made a statement that there is a possibility of Plume moving to, let's say, the opposing party's property. But you said it is a matter of dispute.
Well, don't let me answer the factual question. Why don't you ask Mr. Rankin if he disputes that?
Yeah, I want some clarification on that.
Sure. Let me address that. And if I may, Mr. Chandler and Mr. Chair, I think there's a little question around the party issue, and I can, if I may, I'd like to address that as well, just for clarity, and Mr. Marble can respond as well. But on the question that Dr. Mpoma is asking about whether or not there's a dispute over whether the projected plume will extend onto Desert Ram or HydroSource's property, and I think one of the questions I have as well is what is the relationship between HydroSource and Desert Ram? I'll talk about that briefly when I address the party status question. But in the plume modeling, Dr. Mpoma, that has been presented to the commission over time from the beginning, prior even to Northwind's acquisition of these interests, its predecessor in interest, has always demonstrated, has projected that based on the volumes expected to be injected, that the plumes would extend anywhere from 2.6 miles to around 2 miles, and in this case, about 1.8 miles from the Titan treating facility. So the plume modeling has indicated, based on, as it's been refined over time, based on additional data, 3D seismic information, additional information on the porosity and permeability, the plume modeling has changed over time. But currently, based on the best information we have today, as presented in the testimony and evidence, the plume modeling suggests that during maximum injection rates over 30 years, that the plume is likely to extend or may extend out to about 2 miles, which would go into offsetting property owned by HydroSource and or Desert Ram. Now, the point on that I made in the opening, in the legal argument, is that Northwind believes that it has the consent and agreement of HydroSource to inject through multiple AGIs into the pore space. And that is an issue of dispute. And that, in our view, is a matter for the district court to determine. But as for purposes of the commission today, what we will show, and what the evidence shows, is that we have more than 200 acres of property rights that include the bottom hole locations, the surface locations of the facilities, and the AGI wells, and that Northwind has previously presented testimony and evidence showing that the plume is going to extend beyond that distance prior to acquiring additional property from HydroSource, and HydroSource has never objected, strongly indicating that they understood and had consented to and agreed to the injection as has been proposed for many years. So that's the plume issue. The party issue, just to clarify, is the following. Under the commission's rules, parties in division or commission hearings are limited to those persons who are required to receive notice under the division's regulations. In this instance, for purposes of injection, persons are required to receive notice if they are an owner of the land surface on which the injection well is to be located. In this instance, the location of the surface where the injection well is to be located is Northwind itself, not HydroSource, not Desert Ram. Okay, so the first group of parties who are required to receive notice is the surface owner on the well's location. That is Northwind. It is not, and the bottom hole location as well. It is not HydroSource or Desert Ram. The next group of people who are required to receive notice for an application to inject are other affected persons within any tract wholly or partially contained within 1/2 mile of the well. Under the definition of affected persons is the following. An operator as shown in division records, so a division designated operator, somebody who has a mineral right or is an operator of a well. In the absence of an operator, each working interest owner who has a mineral interest, whose interest is evidenced by a conveyance or a document of record. And if there's no working interest owner, then any lessee or a lease or any mineral interest owner of a lease within one of those tracts. Again, it's limited to the mineral interests or mineral rights. Under the divisions and commission's express regulations, the only parties who are required to receive notice, therefore, are parties who have a ownership interest at the location of the surface of the well. In this case, that's Northwind, who also owns at the bottom hole location, or any other operator under the division's records or owner of a mineral interest right. That excludes HydroSource and Desert Ram. They inadvertently received notice in this case. They weren't required to receive notice, and it may have been an artifact of their prior ownership of the surface where the well was located. But in this instance, they were not required to receive notice, but they did. So under the division's regulations, they are not a proper party to this proceeding. The other alternative for them is to have intervened in this matter. An intervention requires them to show standing. Okay, standing in this context requires them to show some injury that is legally cognizable or relevant to the proceeding before the commission. Here, the proceeding before the commission is the technical question of whether or not Northwind's application for an AGI well should be approved. The arguments, the technical merits around that case do not extend to or include or implicate pore space rights, concerns about subsurface trespass. Therefore, the alleged injuries, the gross negative consequences that they're alleging, okay, are not within or not relevant to the proceeding currently before the commission, and they do not confer on HydroSource or Desert Ram standing necessary to be a proper intervener. Not only that, but Desert Ram and HydroSource did not properly intervene in the case. They did not file a motion. They have not established any basis for standing relevant to the claims before the commission in this case. So for that reason, the first element that Mr. Chandler has articulated to you, they have not met. They're not a party. And so therefore they have no basis to seek a stay. The second element is whether or not it's necessary to prevent waste or protect relative rights. Again, they have no mineral interests. There's no waste allegations because there are no mineral interests or minerals at risk here in the Devonian. The commission and the division have already determined that there are no mineral rights or minerals at risk in the Devonian because they've already approved previously in the same exact location AGI disposal. And then finally, on the last element about gross negative consequences, again, gross negative consequences must be read to be understood in the terms of whether there's some aspect implicated by the commission's authority, which relates solely to protecting waste, corella rights, human health, or the environment. None of those issues have been raised or articulated as a basis for a stay by Desert Ram. So for that reason, the motion for stay, in our view, should be denied.
Mr. Marble, please.
Brief, sir, rebuttal, Mr. Chair and commissioners, to address what council discussed earlier as the two elements being a party and then a party who has suffered gross negative consequences. I'll admit I'm happy to play dumbest guy in the room very often, but I'm very confused by Mr. Rankin's argument that we do not have standing. It is very clear from the commission's rules that a party to an adjudicatory proceeding shall include, that is a party withstanding to the proceeding, shall include a person to whom statute, rule, or order requires notice. 1915-412A7 requires notice to any surface owner within a half mile of the site. There is zero factual question here that Desert Ram North Ranch Inc. is a surface owner within a half mile of the site. And under the rule that I mentioned just a moment ago, that is a statute requiring notice. Thus, they are a party. So we satisfy the first element of what council mentioned a moment ago. The second element is that if a stay is necessary to protect gross negative consequences. And let me divert just for a moment about a question that Dr. Ampoma had a second ago about the deviations between plume models. We are not offering, as Desert Ram, any alternative plume model because every plume model offered by Northwind shows that it encroaches on the property of Desert Ram. You'll see here in a moment when we begin to present evidence, but the land that was sold by Desert Ram to Northwind has a U shape around it. That is land that was retained by Desert Ram. And then there is more land to the northeast, more land to the southeast, and then Desert Ram is also the lessor of, the lessee of state lands on the other borders. So almost the entire tract is surrounded by Desert Ram, either as surface owner or as the state's lessee. Another question to address that I believe Mr. Chairman might have mentioned a moment ago and Mr. Rankin addressed was the relationship, or excuse me, council addressed a moment ago, was the relationship between HydroSource and Desert Ram. HydroSource is merely an operating entity with common ownership from Desert Ram. Desert Ram is actually the entity that owns the surface. Now, I'll tell you that when you look at Northwind's application, figure B1, page 81 of 88, you'll see that Northwind provided notice to HydroSource, most likely because they read the requirement that they have to provide notice to a surface owner within a half mile. That was incorrect. We could have filed an objection in this on what my New Mexico ranching grandfather would have called chicken scratch, that they didn't qualify properly under notice to any of the parties. But we received notice. HydroSource and Desert Ram South Ranch Inc. office out of the same offices. So we received notice of the application after we had sold the property to Northwind. And that's when we decided to properly intervene in this proceeding. That's all I have on Sir rebuttal, Mr. Chair.
Thank you. Commissioner Bloom.
Mr. Tremaine, any input on standing or
I was going to ask that too. You beat me to
I
it.
guess standing and topic of gross negative consequences or things along those lines?
Commissioner, I have some questions about, I think, from a technical basis, how that's being calculated, but it has been my understanding that every plume model has indicated encroachment on what's currently referenced as affected pore space from the prior applications. But again, whether Desert Ram or HydroSource transacted into the nuisance, so to speak, is a question for the district court. And I'm not going, I don't think that the division has any further position on standing. I think the notice to affected interest within a half surface mile may require some clarification. That's not an issue that I've looked into, but I don't know if they're calculating that from the edge of the modeled plume or if they are calculating that from the well site. That's not at all clear to me, and I think that may be in dispute. So I'm answering your question with a question. If they are within a half mile of the affected, the area as the commission chooses to define it, then I would have to concede that they would have standing in the case. But I'm not clear on how that's being calculated.
So, Mr. Tremaine, following up a little bit, Northwind makes an application to the OCD, correct?
Correct, because it is an AGI, those applications automatically come to the Oil Conservation Commission. But yes.
And potential loss of use of pore space or economic damages are not something the OCD looks at currently?
In the injection context, there is no current rule establishing how pooling of those resources occur. And I have not done an exhaustive analysis of whether any previous SWD or AGI has affected pore space of differing ownership. That would be something we would have to look into. My concern here is that it has been the accepted practice for both saltwater injection and AGIs for decades that that the division and the commission have that authority. But I can't possibly today speak exhaustively as to whether or not there's differing ownership in those previous cases. We agree that pore space attaches to the surface, and that is interest of some value to be determined by the parties or the courts. Did that answer your question, Commissioner?
I think so. More directly, do you believe that this potential threat to pore space, damages, loss of pore space rises to the occasion of gross negative consequences?
I would have to revisit case law on that point, Commissioner, because I don't know what economic value attaches to gross economic consequences or gross negative consequences, pardon. I think it's undisputed that if you inject treated acid gas into a pore space, that will conflict with other alternative uses. I don't believe that there's any technical basis to argue with that unless there's an argument that you can combine different forms of injection. I'm not aware of that argument. So I would say, yes, if you're filling pore space, that is going to affect a party's economic interest in that pore space.
Might have further questions on some of this for everybody, but I'll leave it there for now. Thank you.
So I have questions as well. I think the questions just can keep coming with this because this is very gray area. And as was mentioned, there's certain parts that have to go in front of the district court and let the courts figure that out. And then there's the questions that this commission is required to kind of fill out as well. I think, as was brought out by commission counsel, there are some aspects to 1915 423B, especially with, who is the actual party and then the consequences that go therein. And I think that potentially this commission would want to potentially hear what's going on, at least to see where this gross negative consequence would be. My concern, though, is that Desert Ram, and it's not necessarily a concern, it's a thought I'd like everybody to think about. Desert Ram suggested as of last night some conditions that they would like to see in an eventual order at the end that they would want this commission to potentially add on to any decision that they would make. Now, some of these, and I'm not going to go into details, everybody got it, you read it, you know what's going on with it. But it seems to me, and commissioners, I'd like your position on this as well, that some of these sound reasonable, and maybe you go back to the drawing table outside of this commission and come to some conclusion with potentially these in mind. They're an option. I don't know if it's an option that has been considered as of such. They were submitted late yesterday afternoon, so I don't know how much time Northwind had to review them, and I'm not going to try to force anything down anybody's throat. But my suggestion is potentially going back to the drawing table and seeing if there's something that could be written up between a consensus between the two parties, three parties, including the OCD, and getting the OCD's opinion in on this as well, to see if there's could be some kind of amicable conclusion that can come up between the parties. Because either way, any way this commission goes, the parties will not be happy, though there is an option here to be able to provide a path. Commissioners, I don't know how you feel about that, but my suggestion is that the parties kind of go back to the drawing table and see if they can find an amicable solution with the potential of these conditions to be added. I'm not saying that they're right. I'm not saying that they're wrong. I'm just saying they provide a path that, as of last night, was not possible. That's my decision. I mean, not decision. That's my opinion. Commissioners, I'm happy to entertain questions, and I will open it up as well. If you get commissioners, if you want a moment to think, I'll open it up to the other parties, and we go from there.
Mr. Chair, so, Mr. Rankin made some points, I just want to know that, let's say, if we're injecting into your pore space and you move into someone's pore space, is Mr. Rankin saying that, or is it the position of the petitioner that let's say if you inject into someone's, more or less move into someone's space, they do not have the right to more or less question why you put in that gas into my space, because I could use it for something else. So HydroSource did not oppose to your earlier applications. They knew that there was more or less a movement of the CO2, or let's say the tag, moving into their space. They decided not to oppose. But now here comes another owner who says, no, I oppose to that. So I find it so confusing that you say that they do not have a stay, like they do not have any position on this with regards to there's no oil and gas there, to be impacted, but it is in their pore space. So I do support the chair that I feel like they have to go back and talk through this. I mean, I don't think we should neglect the fact that, let's say, tag moving into someone's space, we should neglect that.
I agree. Let's throw it back as an option so that they can give us their ideas, and then we go from there. But please, Commissioner.
Yeah, so you talked about if these conditions could be accepted, or let's say could be discussed and then come to a consensus. But when I look at these conditions, I mean, how would you say that permit limited to 15 years? I mean, Northwind is required to report to OCD the status of monitoring wells result. This should be OCD's conditions, not an opposing party's condition. So I don't know, I would not agree that, let's say, Northwind should not more or less agree to these conditions without evidential evidence to substantiate why these conditions, should even come into play.
And I just want to clarify one more time. I'm not saying that these conditions are right or wrong. I'm not saying that we have to adopt these conditions or anybody has to adopt the conditions. I'm saying it opened the means for some more dialogue outside of this commission. That's what I'm saying. And I think it would be more amicable to everybody if there was, not amicable, it would be more favorable to everybody if there was an amicable consensus. That's what I am throwing out. I'm happy to hear this. I get paid either way. My job is to sit here and to do this, and so is the other two commissioners. I just think that you're not, well, no, you're on your own, right? We love you anyway. But I'm just saying that it opens the door that was not open up until yesterday afternoon. Mr. Marble.
Understood, Mr. Chairman. And to make sure that we're all on the same page, there has been no meaningful conferral on these conditions, partly because of time, partly because of what was going on earlier this morning and other involvement of council. I do think it's worth a shot for meaningful conferral. I know in some other jurisdictions at this point in a hearing, it would not be unorthodox to say, let's take a 30-minute break so that you can confer. I am happy to state on the record that if we could get these conditions or some version of these conditions, we would be happy to withdraw our intervention and protest subject to no prejudice of our district court filing, and you guys can go on with your day as normal. So if it pleases the commission, I would love the opportunity for meaningful conferral with opposing counsel.
Mr. Rankin.
Well, whether or not to even confer, I need to confer with my client.
Of course.
My position at the outset is that many of these are problematic, not least because it's inappropriate to even concede that they're appropriate for inclusion within a commission order, where the motivation and the purpose behind them is to protect the protection of private property interests that unrelated to mineral rights or correlative rights or any of the underlying authority or jurisdiction that underlies the commission's powers. So I have grave concerns about even agreeing to allow these to be included in a commission order issued under the auspices or imprimatur of the commission. Okay, number one. To address Dr. Mpoma's concerns, I'm not saying we're not saying that they don't have a right to make a claim that the plume intruding into their alleged property rights or pore space is something that they have a right to bring forward. Okay, they absolutely do, but not here, and not at the division or commission. They have a right to do it, and they've done so as they recognize before the district court. They filed a complaint, and they're pursuing that action in district court. And that's the venue through which they have the right and the proper proceeding to pursue those claims. As to the commission, whether or not this results in a gross negative consequence to them, to Desert Ram or HydroSource, requires the commission to make a determination about ownership. Ultimately, they have to make you'll have to make some determination about whether there's a valid claim as between Northwind or Desert Ram or HydroSource about whether or whose interests are being impaired or not. At some level, that's a requirement that you're going to have to make based on what Desert Ram or HydroSource is asking you to do. And our point simply is all we need to do is show that there's a good faith basis. And we have that based on the deeds that are of record. And we have that based on the consent and acknowledgement of HydroSource from the prior applications and approvals that have gone forward in the language that they put forward before the commission in their motion to stay. So I do have grave concerns about even acknowledging or putting these conditions in an order. If at the commission's pleasure, I would happily take a 15-minute break to confer with my clients to see if they would like to see. I got a note. Yeah. Whether they would like to, engage on discussions about this, but I think the answer is probably going to be no, just given the nature of the requests and the venue here. The parties have been having some discussions, and they haven't been fruitful, which is why we're here, and which is why they filed a lawsuit. And so I'd love to be able to tell you that there's a path forward for resolution, but at this point in time, there isn't. And my sense is that I think some of these, to Dr. Mpoma's point, whether these conditions are appropriate should be heard. There's some evidentiary issues that need to be addressed. Is it appropriate to put additional penetrations into an acid gas plume? providing additional potential pathways for acid gas, for CO2 to escape into shallower formations. That's a concern. The expense of it is a concern. Drilling monitoring wells into the Devonian is an expensive undertaking, and do the costs outweigh the benefits? There's a number of issues I think that would need to be addressed, not least of which is whether or not this even falls within the authority of the commission to require.
Thank you, Mr. Rankin. I do want to hear from the OCD first, Mr. Mervin.
Mr. Chair, Commissioners, on the topic of try to limit my comments to the topic of the additional conditions, I think that notwithstanding the relative position statements of the other parties, I think getting an adequate factual basis and OCD's review of the additional conditions requiring Devonian monitoring wells is going to take more than 15 to 30 minutes. We're going to need some time to do that. We saw these last night. There are some very legitimate concerns with those conditions. I'm not coming out with a strong position that they should or should not be included in a commission order, except for I would note that, in prior monitoring, whether surface monitoring or wells requested by the division and imposed by this commission have always been, in our opinion, for the purposes of alerting the division and the commission if something went wrong, right? We have surface monitoring near potential points of egress or migration of treated acid gas from neighboring wellbores. There's a concern related to previously plugged wellbores, et cetera. So we ask for surface monitoring in those locations. I believe we have requested downhole monitoring or other surface monitoring at existing wellbores at the perimeter of the projected plume. So in every case that I can think of, and that we've discussed with the technical OCD's monitoring, whether it's well or surface location, have been for the purposes of either verifying the accuracy of the plume modeling or early detection in the case there is migration of treated acid gas or CO2 as a precursor to the migration of treated acid gas. So those are safety, human health and safety, environmental concerns that are addressed. The wells that are proposed here, one, are a set of wells that I believe will necessarily be placed in the middle of the projected plume. They are not for the purpose of determining whether the plume modeling is accurate. They're not for the purpose of determining whether treated acid gas is migrating outside of the containing zone. So they're not a typical monitoring purpose that OCD has requested. I do understand and respect that as part of the commission's duties to protect correlative rights. So there may be some need to consider such monitoring wells here, but the purpose seems to be for identifying for the neighboring property when, not if, their pore space is encroached, right? And that ultimately comes down to a question of when can they start billing the opposing party for that encroachment. That financial consideration or that dispute, I do agree, is not necessarily before the commission. And so I think, or not appropriately before the commission. So there's that. There's also additional technical bases. OCD does have a generalized concern that additional perforations from surface to the Devonian cause potential migration pathways for treated acid gas. Those wells, as you can see with all the other wells that are referenced in OCD's conditions of approval, et cetera, we're asking for corrosion-resistant alloys, corrosion-resistant cement, surface monitoring, et cetera. So I don't know how many wells they want. I don't know where they're located. They're not pled in the conditions with, I think, reasonable specificity. So OCD would need to know how many they are, where they are, what those wellbore schematics are going to look like. Are they using appropriate corrosion-resistant materials, et cetera? Again, pushing back on whether those financial considerations are appropriately before the division, I would acknowledge Mr. Rankin's comment that those wells are expensive and that is going to weigh into the consideration of the parties. But if they are determined to be appropriate safeguards, that question is really not before. I think that economic analysis is similar to my comments related to Desert Ram. Those considerations by Northwind are not before the commission either. I think the question is before the commission is, are these wells necessary for the protection of correlative rights? And then are there appropriate safeguards in place to protect those correlative rights, public health and the environment, underground sources of drinking water, et cetera? And because of the way that the plume is currently modeled, I think the area that we're talking about for monitoring is known or expected to be impacted by treated acid gas in terms of the pore space. So poking more holes there, it's hard to justify from the division's perspective as safe and appropriate. It really gets to the question of the gross negative consequences that may or may not be experienced by Desert Ram. So we need to know what they actually want those to look like, where they are, how many they are, et cetera, before Mr. Gebermichael can actually perform an analysis of whether those are, one, necessary and appropriate, and two, have appropriate safeguards.
Mr. Chairman, to say that, let's say, even these requested monitoring wells are appropriate or not, I mean, are these typical conditions that are ever, attached to any AGI, let's say, wells?
No. I believe I can try to pull the order, Commissioner Mpoma, but I believe that we have requested wellbore monitoring at neighboring existing wells. But again, those are whether that's surface or downhole monitoring. Those were always requested for the purpose of verifying did the plume go farther than it was projected to go? There, we're going to say this is the perimeter. If you get to this point, something's gone wrong. If you trigger a surface monitor at a neighboring wellbore of a previously plugged well, for instance, like we're requesting, and I believe OCD condition of approval, either 11 or 13, I can pull it up, but we are requesting surface monitoring at neighboring plugged and abandoned wellbores because there's a potential that there could be a corrosive reaction and CO2 or treated acid gas could migrate to the surface at those locations. Again, public health, safety, verifying the science and the plume modeling in place. We've never used or advocated for additional perforations to see when treated acid gas gets to a certain point. And I do agree with Mr. Rankin that the purpose of those monitoring wells is to alert Desert Ram to when their pore space is impacted. And that's a money dispute between the parties, a timing and a money dispute.
Mr. Chair, I don't know, let's say how you want us to proceed with this, but I will require that probably we go in a closed session to just look at this quickly and probably return because I do have some questions for the council.
Before we entertain that, Commissioner, Mr. Marble, you wanted to state something.
I do. A couple of small points. To the doctor's point about the appropriateness of these conditions on the permit, I understand that they are unique and different. Two things that I'd like to say to that regard. One, my client does operate water wells within the area that could theoretically be impacted by this plume. In fact, in the application from Northwind, you'll see that they got notice in the context of being a water well owner that they could be impacted by the application. The second piece of that is I'd like to point you back to Snyder Ranch. Snyder Ranch has kind of been the seminal case on describing the function of this commission when it issues a permit. They go on to describe it as a license. And then the Snyder Ranch case goes on to say that license is limited to bestow upon someone the right to engage in activities within their property rights. And here, I believe it would be appropriate for the condition that the commission places on the permit in the context of that Snyder Ranch's dictate on what the commission's power is to make sure that the applicant is engaging in activities within the scope of their property rights. And one thing I want to say in response to something Mr. Rankin said in his last statement He mentioned that it is inappropriate for this commission to make interpretations or to determine who has a valid claim to property. I agree with him. I agree that that's inappropriate for this commission. But the difference here is that there is no claim to property that Northwind is making. There's not one document that they can put in front of this commission saying they have the right to do what they want to do on Desert Ram's land. Those are the only small points I'd like to make.
Thank you, Mr. Burble. Mr. Commissioner Bloom, did you have any questions, thoughts?
So Mr. Chair, I think we did hear from Mr. Rankin that he could use 15 minutes to confer with his client. If nothing else, that would give us a bathroom break.
I was coming up to that one. You're just a step ahead of me today.
Okay. And then, after that, there might be some potential for the parties to talk. And then I guess I was trying to think where we're at. I think my allergies are just killing me today. My eyes are bothering me. I feel sluggish. But
that's like a alligator.
So we need to figure out. Yeah, we need to figure out the ruling on the potentially on the motion, and then I think the potentially hear a permit discussion. Is that right? Evidentiary hearing.
So correct. I think we do need to go to a break and allow, first off, all of us to stand up and maybe get some fresh air. Please.
Mr. Chair, in the consideration of the entire universe, is Northwind, have they had a chance to review the OCD conditions? And can you proffer whether they're going to be contested or not?
Thank you, Mr. Chandler. No, the conditions that the division has proposed, which were filed at the time of its pre-hearing statement and its exhibits, have been reviewed by Northwind, and as we will testify, those conditions are acceptable to Northwind.
So I still throw it out there to pose potentially for discussion. I'm not saying, and I don't think this commission is saying, that what Desert Ram has proposed is what needs to be done by any means. I think it just, as I mentioned, opens the door for conversation for them and for Northwind to be able to potentially find some type of middle ground. I realize, Mr. Rankin, the conversation has been going on, and that's why we're here where we're at. But it did look like an 11th hour effort to potentially open up the discussions. And so I would urge you and your client just to look at it. I'm not saying be open to the thought. I'm not saying that you have to, and I'm not saying you don't have to. Be open to the thought and do that. So why don't we take, let's take a good, what time is it? Would a half hour be good for you? Okay, let's take a half hour break, and we'll reconvene at 11:30. Thank you. Good morning to everybody that's on the platform. The parties needed 15 more minutes, so we will reconvene at 11:45.
Now they have more wells.
Okay, thank you for everybody for holding on the platform. We need about 5 more minutes. They think they have a decision, so we'll get back in 5 minutes. Okay, Sheila. On the platform, thank you. We're back on the record. It was an extended period of time. The half hour took an hour, but that's okay. Is there a resolution to what we have? I'll start with you, Mr. Marble. If you'll turn on your microphone, please.
There is, Mr. Chairman, if it's okay with Mr. Rankin, would you like me to walk through it on the record? In exchange for withdrawing our notice of intervention to the application pending today, the applicant will accept all the conditions imposed by the OCD.
Okay.
And specifically as to condition 18, which is relating to plume modeling, the applicant has agreed that instead of every 5 years, it will be every 2 years. And as it relates to condition 13, there will be, did you want to read this one onto the record or did you want to address it?
Yeah, I guess one thing, just to be clear, so in the division's conditions, it's condition number 13, the division has proposed that Northwind implement surface monitoring at certain plugged and abandoned wells that penetrate the Devonian. And what we've agreed to do is have a side agreement between the parties where Northwind will put a surface monitoring device on one of HydroSource's water wells in section 29. So we would do that outside of the permit conditions, but have an agreement separate between the parties to implement additional monitoring on one of their water wells in section 29.
And then I think the only other thing to be addressed in the side agreement was as updated plume modeling information relating to the permit condition on 13 all becomes available. That would be simultaneously provided to Desert Ram at the same time it was provided to the commission.
Okay. So thank you, Mr. Marble. Mr. Rankin, you're good with what was stated.
Yeah, so just to reiterate, just for purposes of the record and to confirm my understanding, that what we've agreed to do in exchange for HydroSource and Desert Ram's withdrawal of their objection to the proceeding in this case is that we would agree as a condition of approval to increase the updating of the modeling and data provision under condition 18 to 2 years instead of 5. And we would separately, on a separate side agreement, we would agree to give Desert Ram and HydroSource all the information that we provide to the division and commission at the same time as part of the conditions of approval of the permit. That would be a separate side agreement. And then the third item is also under separate side agreement that we would agree to put a monitoring device on one of their water wells in section 29. And then we just would need to be authorized to get access to do it, because I think we have to check the equipment and update the data every month or so, whatever the frequency is. But those would be addressed through the side agreement. The only thing that would go into the conditions of approval here would be to increase the cycling of the plume modeling in condition 18 to every 2 years.
Excellent. Thank you. Appreciate it. Mr. Tremaine.
More plume modeling updates is probably more better. No objections.
More better. Your English grammar is awesome there, Mr. Tremaine. Okay, commissioners, any questions on what was stated?
Not from my side. Thank you.
No questions, Mr. Chair.
Excellent. Mr. Marble, we'll ask if you could write up all of the conditions and submit them for the record so we could have it all ready to go and then get every party to sign off on it and then submit it to the commission.
Absolutely, Mr. Chairman.
Mr. Tremaine, did you have something? Oh, okay. Go ahead, Mr. Chandler.
So what needs to be memorialized? Are parties looking for a motion from the commission today?
I'm not sure that anything needs to be memorialized other than I guess that the Desert Ram will submit maybe a formal withdrawal of their objection as and when they're satisfied that we have entered into the side agreement. And then the only other element would be, which I think is sufficient for the statement of the record, maybe the division can submit a revised Exhibit 1, which would be simply just to update the frequency of the plume modeling and data to 2 years instead of 5.
Mr. Tremaine?
I think at the close of the factual record to come, it'll need to be memorialized that condition 18 has been modified. But I think we can do that either in writing, submit an updated condition 18 or on the record. It's a simple correction. I don't think any of the side agreement settlement between the parties needs to be memorialized by motion or order of the commission.
Okay. Mr. Chandler, did that suffice for your question?
I beg your forgiveness since I'm so new. Did you say, Mr. Counsel, that you needed some technical testimony put on the record?
Well, I think I was operating, counsel, under the assumption that the commission was going to still want to hear the underlying application by Northwind. Because there isn't yet, it wasn't submitted by affidavit. And so there is not a record upon which the commission may approve I thought we still had to have a hearing. Yeah.
Commissioners? So we'll still have a quick hearing.
When you say a quick hearing, I mean, probably not quick, but yes.
It won't be quick, but I don't think it will be as long as it was slated to be.
When will we be doing that, Mr. Chair?
How long do the parties need?
I think we have lunch waiting for us at our office, so probably just an hour. If we can be back here at 1, maybe 1:15, that we can start. I think probably we can walk through, depending on Dr. Ampoma's questions or the commission's questions. I think it might be maybe just a little more than an hour, hour and a half, maybe to complete the record. And with with the division's witness, maybe another 20 minutes, hour and a half, maybe to complete the presentation of the case.
Commissioners?
That works for me.
That works for me too, and I promise we'll get it done today.
You're our limiting factor with questions. Okay, so it is 12:03. We'll give ourselves a little bit of a longer lunch. Let's come back at about 1:15. We'll proceed with the case, but at least we won't have it as controversial. So thank you all. We'll see you at 1:15.